This is Michael Popok. Breaking news. A federal judge, Judge Lewis Kaplan, has ruled against Donald Trump in his efforts to downplay the jury's verdict in the E. Jean Carroll sexual abuse case, finding that in his written report, Judge Kaplan finding that she was, in fact, raped, as that word is commonly used, and that the jury was appropriate and right and not erroneous in not only finding that Donald Trump had sexually abused her or digitally raped her, but that their award of $5 million in total damages, including punitive damages, was just and not a miscarriage of justice. So the judge refused and denied Donald Trump's motion to both set a new trial and start all over again, and or reduce, by way of a doctrine called remittiture, reduce the amount of the judgment from $5 million down to the $1 million that Donald Trump wanted to pay for what the jury of 6 men and 3 women in a 9-0 vote jury verdict returned in 2.5 hours, almost before they had lunch, that he sexually abused her, digitally raped her, and she suffered as a result of that, and defamation against her, in which she was also injured. The judge completely denied Donald Trump's attempt to get out from under that, short of appeal, will not be ordering a new trial, will not be reducing the amount, and found the arguments raised by Donald Trump to be frivolous. And that's a signal to E. Jean Carroll's lawyers, Robbie Kaplan, to file a motion for sanctions and ask for sanctions, because you're not allowed to maintain frivolous arguments and cause the other side continued pain, victimize the victim, make them spend more money without repercussion. And the repercussion for that are sanctions, which I'm sure will be happening next. Let's break down the 59-page memorandum opinion, docket number 212, docket entry 212, today in the case. I'm going to read, because this is what Donald Trump forced the federal judge to do. If you're asking for a new trial, you're going to force the federal judge to recite all of the evidence against you, all of the things that happened in trial, all of the testimony, the jury instructions that were given to the jury by the judge, the result, the verdict form, all of it. And the judge did it in a very succinct way in 59 pages in reciting 8 or 9 days of testimony. And let me just read from some of these things and the highlights of them. And we'll put some of them up on the board here during the hot take. First of all, the judge blew apart Donald Trump's argument that he wasn't adjudged a rapist, and therefore he was vindicated by the jury. The judge said, look, New York has a unique definition, unlike other states, that requires a male penis to go into a vagina in order for that to be rape. Short of that, it's sexual abuse. So what is commonly referred to, unfortunately, as digital rape, where you use a finger, another body part, or another instrument, is not considered technically rape in New York. But the judge said, in the common parlance, okay, in everybody else's common view, what Donald Trump was adjudged by that jury to have done to E. Jean Carroll in a dressing room, in a department store in 1996 is rape. And the judge said, that's rape. He also reminded them in his order, the judge reminded everybody that the jury verdict form, which the jury then ticks through in making its decision, was approved by both sides, including Joe Tacopina, the lawyer for Donald Trump. So you got nobody to blame, if you don't like the way the jury kind of cycled through the decision-making tree, which is the verdict form, to reach a decision. They were told in the jury verdict form, there's 3 things you got to decide. Did none of it happen? Was she sexually abused because something short of Trump's penis went into her vagina? Was she raped because a penis did go into her vagina, or was she sexually attacked in some other way? Those were their 3 choices. And then if you if the jury chose one of those 3 choices, rape under the hyper-technical definition in New York, sexual abuse, or forcible touching, You touch somebody somewhere else in a sexual way against their will. That is another level. And all that verdict form, which Joe Tacopina approved, said is if you find rape, sexual abuse, or forcible touching, go down to the bottom and work out the amount of damages you're going to award for that sexual abuse. In other words, the verdict form said if you entered yes for any of rape, sexual abuse, or forcible touching, right? And then you have determined, this is from the verdict form, that the defendant, Trump, has lost and the plaintiff has prevailed on her claim of battery, sexual battery, and go award her damages. That's all it said. And that's exactly what this jury did. And this argument that the jury could have concluded based on the weight of the evidence, more than a dozen witnesses and all of the other evidence that was presented, that they could have concluded that it was some sort of just touching, improper touching, like of her shirt or on her breasts. The judge said that's ludicrous based on the weight of the evidence. And the judge went through and recited once again. And for the public that's out there, that's still on the fence about who to vote for come the next election and thinks that maybe this was all a hoax, let me read from the actual order, which Donald Trump forced this federal judge to put into the public record once again. And this is, I'm now quoting, "This case was tried in April and May of 2023. Ms. Carroll contended that Mr. Trump," he said, then a businessman, "had assaulted her in a dressing room at a New York department store where, among other things, he forcibly penetrated her vagina with his fingers and his penis. She testified in person," this is Carroll, "for most of 3 days and was cross-examined intensively." That would have been by Joe Tacopina. "Her sexual assault claim was corroborated by 2 outcry witnesses in which Ms. Carroll had confided shortly after the attacks and was supported by 6 other fact witnesses. An outcry witness is a special witness in a courtroom. It's somebody hears when somebody else has a crime committed against them. And it's extended to people who are told contemporaneously in real time what had happened, because that is a very high level of credibility when you have an outcry witness, right? The court tells the jury that's a very high level of credibility. The judge went on to say about basically criticizing Trump's defense or lack thereof. Mr. Trump's defense, this is from the judge's order, based exclusively on an attempt to discredit Ms. Carroll and her other witnesses, in other words, by cross-examination, in substance was that no assault had ever occurred, that he did not even know Ms. Carroll, and that her accusations were a hoax. Mr. Trump, however, this is the judge, did not testify in person or even attend the trial despite ample opportunity to do so. The jury's unanimous verdict in Carroll 2 was almost entirely in favor of Ms. Carroll. The only point on which Ms. Carroll did not prevail was whether she had proved that Mr. Trump had raped her within the narrow technical meaning of a particular section of New York penal law, a section that provides that the label rape, as used in criminal prosecutions in New York, must include penis into vagina. As is shown in the following notes, the definition of rape in the New York penal law is far narrower than the meaning of rape in common modern parlance. Its definition in some dictionaries, in some federal and state criminal statutes, and elsewhere. The finding that Ms. Carroll was sexually abused does not mean that Donald Trump did not rape her in the modern parlance, in the common way that term is used. That is from the judge. The judge then went on for 40 pages to outline all of the witnesses that testified. The outcry witnesses, Lisa Birnbach, Carol Martin, who were very credible and believed by the jury because she had called them right after the rape happened, the sexual abuse happened. And the other witnesses that testified, the 2 other women in and around that same time period who said they were sexually assaulted by Donald Trump, the Access Hollywood tape, which came out before the election with Hillary Clinton but didn't change its result, unfortunately. in which he said, as a celebrity, he has the right to grab women by their vaginas. We all remember that tape. That was played for the jury and, of course, had an impact on the judge as well. The judge then spent considerable amount of time basically chastising the defense and telling Tacopina and Alina Habba, who were the two lawyers there, we had a jury verdict for him, which is the way a jury cycles through the evidence in the decision-making tree and renders its decision. I gave them instructions as the judge on that jury verdict form. You developed defense, that jury verdict form, with the plaintiff's counsel, and you approved it and didn't object to it. See, this is how a judge makes sure there's no reversible error in a case up on appeal. You have the other side agree and say, we accept the jury verdict form that you're going to use, Judge. We accept the jury instructions that you're going to give the jury about the jury verdict form and the counts of the claim in the case and the defenses. We agree to that. There was no objection that was preserved by the defense on any of those things, because Joe Tacopina doesn't know what he's doing when he's trying a case. He could have at least objected and said, we don't agree to that verdict form, Your Honor, and we object to it, and preserve it for appeal, but they did not. And so the judge reminded them and chastised them in this recent order today and said, hey, you agreed to this verdict form. I used the verdict form. The jury used the verdict form. We told them if they find one of three bad things happen to E. Jean Carroll, they are to write a number down below for damages, and they did, having found that the second thing happened, sexual abuse, because of the unique definition under criminal code in New York in this civil case. And then the judge went on to say, based on the weight of the evidence and the lack of counter evidence that was presented and the lack of Donald Trump even being in the courtroom, the jury was right to assign the levels of damages they did, totaling $5 million, including punitive damages. And the judge says, I am not, based on this weight of evidence, taking away from the jury and the jury system and removing it from them, their verdict or their amount of damages. So no new trial and no reduction or remitter of a damage amount. And just as a parting shot, the judge went out of his way a number of times in the order to call what Joe Tacopina and Alina Habba did as frivolous, which will be a dog whistle that we all get to hear for E. Jean Carroll's lawyer, Roberta Kaplan, to file now on the heels of this order, her motion for sanctions to get attorney's fees and costs out of Donald Trump on top of the judgment, right? What's up on appeal. And to bring this thing full circle, Donald Trump has already appealed the jury verdict. This was an attempt to get the trial judge below the appeal level, right, to give him a new trial and reduce the amount. He'll try the same angle of attack with the actual full-blown appeal, which will take its normal course at the Second Circuit Court of Appeals for federal. And it will be a year away from getting a ruling by the Second Circuit, because there's no grounds for an emergency application or doing this on any faster track. This will be a year, 14 months before we get a final ruling. Now, Donald Trump had to put up or shut up for his appeal, as all appellants do. So he put up a bond in cash for $5.5 million with a 10% kicker added on, and deposited it with the court clerk. So the court clerk is holding $5.5 million in favor of E. Jean Carroll. If the appeal is denied, rejected and denied by the Second Circuit, then E. Jean Carroll's lawyers can apply directly to the clerk to get the $5.5 million running with interest. If somehow Trump pulls a elephant out of a hat and wins the appeal, which, spoiler alert, I do not believe he's going to do, then they would get the money back. But at least E. Jean Carroll doesn't have to go chasing Donald Trump for money when she wins the appeal. It's sitting there. And now she'll likely get new money on top of that in the form of sanctions for the conduct that happened. In fact, I wouldn't be surprised if there's a motion for sanctions for many of the bad things that happened in the trial, including Donald Trump tweeting and doing social media posting, his son doing the same thing, trying to influence the jury's result. I think we're going to see sort of an omnibus motion for sanctions related to all the things that happened that forced E. Jean Carroll to spend more money during the trial. And now this new item as a list. So I wouldn't be surprised if we see like $1 million attorney's fee bill. And then just to keep this going, there's another trial that's going to happen between Trump and E. Jean Carroll. Well, E. Jean Carroll is the plaintiff again in another round of defamation based on the statements that Donald Trump made a day after the jury verdict at the CNN town hall, in which he said, again, it was a hoax. I never knew her. I never saw her. Not my type. Look at her. Whatever else he said that was completely inappropriate and disgusting. And they're suing now for $10 million, at least in punitive damages, as a punishment, because what do you do when you got a serial defamer in Donald Trump? Do you just ignore it, or do you keep dragging him back to court to collect? And that's what Roberta Kaplan, the lawyer for E. Jean Carroll, and E. Jean Carroll are doing. They're keeping Donald Trump feet to the fire. Every time he defames her, they're going to sue her and bring her right back to Judge Kaplan to help make these decisions. So there's going to be another trial, right, in 2024, early, involving E. Jean Carroll and Trump for civil rape. And if you're keeping track of the Trump on trial calendar, let's just do it this way. You've got E. Jean Carroll's second case in 2024. You've got a criminal state court case involving Stormy Daniels' hush money cover-up crimes and 34 felonies. That's going to be tried in March of 2024, state court, New York, against Donald Trump. E. Jean Carroll's civil case will be in 2024. October of 2023, so just 2 months away, or 3 months away, you're going to have the civil fraud case in state court brought by the New York Attorney General against Donald Trump, the Trump Organization, all the kids except for Ivanka. And that's going to trial, right? Then you've got the Mar-a-Lago federal judge setting a trial sometime in 2024 for the Mar-a-Lago criminal federal case brought by Jack Smith. This week, we're going to get the indictment of Donald Trump and others in the Jan 6 fake electors, clinging to power, interference with the election case, also by Jack Smith. That'll be in the District of Columbia, and that's going to be a 2024 case. And then you got Fani Willis finally in Georgia, who's bringing probably the next 3 weeks a Georgia state court case on conspiracy, likely against Donald Trump, and that trial is likely to be set later. Generally, just to keep track, federal criminal cases over the same subject matter go first. State cases, criminal cases on the overlapping issues, witnesses, and claims go second, so it takes a little bit of a back seat. Criminal takes precedent over civil. So you got federal. If you're doing the rock, paper, scissors, federal beats state criminal in terms of who goes first, and criminal beats civil cases as to who goes first, right? All the cases go eventually. This is just about like the air traffic controller trying to land the planes and who gets cleared for takeoff first. So federal criminal cases get cleared for takeoff first. State criminal cases come in behind it. State civil cases come in last. So if you're sitting on the tarmac and they say, we've been cleared to land, or the cleared to take off, but we're number 27 in line, you're a civil case, likely a state civil case. And that's how this is going to play out. We'll keep track of the Trump on trial docket right here. I'll do it on hot takes just like this one, only on the MeidasTouch Network. You knew that. You're watching me here. Then we pull it all together in a podcast on Wednesdays and Saturdays called Legal AF. I co-anchor it Wednesday, Saturdays, YouTube, MeidasTouch, free subscription. And we put it on audio podcast platforms that are also free everywhere you can get it from. If you like what I'm doing, you can follow me on the MeidasTouch YouTube channel. You can go over there, slide over to playlists. You'll find all of Michael Popok's hot takes sitting right there. And then if you like what I'm doing on social media, you can follow me on all things social media, including now Threads at MS Popok. Michael Popok, Legal AF reporting.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.